Falling behind on rent is stressful, but ignoring the problem only makes it worse. Under the Ontario's Residential Tenancies Act, also known as the RTA, rent must be paid on the date that it is due. But what happens when you can't? Well, that's what I'll talk about in this particular video. My name is Weiting Bollu. I am the CEO at Openroom.ca. I've spent thousands of hours diving into the rental laws of Ontario so you don't make the same mistakes that I made in the past. Oh, they were ugly. When you as a tenant cannot pay rent, the best chance to save the tenancy is to take immediate action. Step 1, communicate early and honestly. As soon as you know that you won't be able to pay rent on time, you should notify the landlord in writing. A simple message acknowledging the issue shows responsibility and respect. You should always detail information such as explain the situation briefly, apologize for the inconvenience, provide a realistic date when payment will be made. The thing is, a landlord is way more willing to work with you when you can communicate than one that just goes poof and disappears. Step 2, offer a written payment plan. Put this proposal in writing and be very realistic. For example, I will pay $600 on the 15th of the month and the remaining $500 on the 30th of the month. The landlord is not your personal banker, and it is reasonable for you to seek temporary help from family, friends, community resources when necessary. Rent is a priority payment. Housing stability depends on it. Step 3, expect the N4 notice. It's coming. If rent is not paid, the landlord will likely issue what's called the N4 notice to end a tenancy early for non-payment of rent. This is a legal document required under the RTA, and the N4 will always include how much rent is owed, a deadline, which is otherwise known as the termination date, to pay the balance that is outstanding. If you pay in full before the deadline, the N4 becomes void and you can forget about it. If the rent is not paid by the termination date, then the landlord can file an L1 application, which is an application to evict the tenant for non-payment of rent and to collect the rent the tenant owes. They'll also be at the Landlord and Tenant Board, also known as the LTB, to seek eviction for non-payment. A copy of what that looks like can be found in the description below or directly on the LTB's website. Step 4, a formal LTB payment agreement. Remember that payment plan you offered in writing in step 2? Well, there's a more formal one for when it gets really serious. Your landlord must have had filed that L1 application, and then they can then go with you to the LTB to arrange a form called a formal payment agreement. But let's talk about a payment agreement, what it cannot have. Agreement to end the tenancy or evict the tenant. Include any repayment of any non-rent arrears amounts owing by you, the tenant. What happens after this form goes to the board? Well, if the landlord files a copy of this agreement with the board will decide whether to make an order based on this particular agreement. After this form is filed, the board may issue a consent order. And if there is a consent order that is issued, the hearing will be canceled. If the board does not issue a consent order, then a hearing will take place as scheduled, or a hearing will be scheduled. More on that later. Overall, it's not mandatory to sign this agreement. Rather, it's an option to avoid going to the tribunal. You may want to consult a legal representative before you do this or sign this, because once the payment agreement is signed, it is a legal contract. Step 5, if a hearing is scheduled, attend. Do not ignore the hearing notice. If you attend, you have the opportunity to explain why you fell behind, show proof of payments made, offer a payment plan again, demonstrate how you will stay on track going forward. The LTB may allow the tenancy to continue if you show a clear plan and willingness to catch up. If you actually end up at the tribunals, though, you might find our free template for evidence preparation very handy. Link to it is in the description below. But you're probably asking me, Weiting, why does it even matter? Well, a non-payment of rent order may affect your ability to rent in the future. Once you land at the tribunals, the results and discussions may become publicly accessible. That means your name and address can be searchable by the general public. But more importantly, some landlords report unpaid debt to consumer reporting agencies such as Openroom, and it could land on your credit history through Equifax or TransUnion. This may impact your future rental applications or even a mortgage application later on, so you might want to think about it. But let me show you what this actually looks like. Here, you'll see that there are several sections to a consumer credit report. It gives you a financial history about you. And this is an example of an Equifax credit report. One of the sections is called the collections or derogatory section. Once a record hits this particular section, it stays there for 6 years. If a creditor, in this case a landlord, hits your credit, it would look something like this. The agency who marked your file, like Openroom, who the creditor is or the landlord, how much is owed, and that status is still unpaid. You can learn more about our rental debt ledger and how it works in the description below. Okay, it's time for our rental trio, the key points that I talked about in this video that I want you to take away with. First, life happens, but communication can make the difference. 2, offer a payment plan. Not paying rent is not an option if you wish to keep a roof over your head. Number 3, protect your credit and name by making a payment plan and keeping your word. Honestly, at the end of the day, a tenant who communicates, pays rent as soon as they can, and follows through on agreements stands the best chance of keeping their home and protecting their credit. If you enjoyed this, give me a thumbs up and press subscribe. Until then, I will see you next week.